dynamic society. Moreover, the doctrine that the law is always speaking aligns with the purposive approach to constitutional interpretation as endorsed by courts in various jurisdictions. Under this approach, courts are required to interpret constitutional provisions in a way that gives effect to their underlying purpose and objectives, rather than adhering to a rigid or literal reading. Further, courts have emphasized the need for a flexible and forward-looking interpretation of the Constitution to meet the needs of a modern state. With the above interpretive principles in mind, we will now deal with other issues posed in the application under consideration.
I will deal with the second issue on whether the DCJ can assign judges pursuant to Article 165, Sub-Article 4 of the Constitution. There is no doubt that this was the most contested issue in the subject application. Article 165, Sub-Article 3 and Sub-Article 4 of the Constitution provide for empanelment of benches of an even number of judges as follows. Permit me not to go through that. In dealing with the above issue, courts have taken two diametrically opposite positions. One of them being that the assignment of judges is a constitutional duty which can only be undertaken by the Honorable Chief Justice. As such, the Honorable DCJ cannot assign judges under Article 165, Sub-Article 4 of the Constitution. The other position posits that although the duty to assign judges is provided for in the Constitution, its implementation is administrative, and that duty can be undertaken by the Honorable DCJ. In Kenya Medical Research Institute versus AG, which was a 3-judge bench of this court, held as follows. The quote, paragraph 37. Therefore, by empaneling this bench, the Chief Justice was carrying out his constitutional mandate as opposed to similar functions under the former Constitution, which were hinged on the constitutional provisions and were merely administrative. End of quote. In Leina, Conchela, and others, which was a 5-judge bench of this court, the court went ahead and described the role of the Chief Justice under Article 165(4) as constitutional as opposed to a merely administrative function. It also said, it is our view that a constitutional mandate of the CJ can be judicial, administrative, or political, and the current Constitution does not indeed state that the Chief Justice is the head of the judiciary which embodies all these functions. The learned judges in that empaneled bench then found that the constitutional mandate exercised by the CJ under 165(4) of the Constitution is an administrative function. The court also elaborately dealt with the issue as to whether such an administrative function could be undertaken by the Honorable DCJ, and in the end, the court rendered itself as follows. I quote paragraph 78. It therefore our finding that constitutional function of the CJ to assign benches under Article 165(4), being an administrative function, can be performed by the Deputy Chief Justice when the Chief Justice is for good reason unable to perform. End of quote. The petitioners in these matters also cited the decision in Okoiti versus JSC and another, which is Constitutional Petition number A408 of 2020, as buttressing the position that the assignment of judges is a constitutional mandate and the sole preserve of the Honorable the Chief Justice. The decision was delivered by yours truly, who is part of this expanded bench. We have carefully considered the said decision. One of the issues therein, which may be said to have a bearing on this matter, was whether the Honorable CJ could rely on Section 5, subsection 4 and subsection 5 of the Judicial Service Act to authorize the Honorable DCJ to serve as the acting Chief Justice when the Chief Justice was proceeding on leave pending retirement until when a succeeding Chief Justice was appointed. As the matter did not deal with the nitty-gritties of the aspect of assigning of judges, but rather the constitutionality of the actions of the CJ who was exiting service, we respectively find that the issue is not at par with what is under consideration in this instant application. The said decision is hence distinguishable. Returning to the matter at hand, it is imperative to look at the various terms which come to play in this matter, including the administrative actions as well as judicial actions. We have gone through that. I do not think there's need for me to read all that. It's in the ruling, and I proceed to state that from the above discourse, we do not find any difficulty in affirming the position that a constitutional mandate of the Honorable Chief Justice can be judicial, administrative, or political. We further find and hold that the constitutional mandate exercised by the Honorable Chief Justice under Article 165, Sub-Article 4 of the Constitution, is a constitutionally administrative function. We shall now consider whether the function of the Honorable Chief Justice under 165, Sub-Article 4 of the Constitution can be performed by the Honorable DCJ. Article 161 of the Constitution establishes the office of the Chief Justice as the head of the judiciary, and that of the Deputy Chief Justice as the deputy head of the judiciary. Article 163 of the Constitution creates the Supreme Court and designates the Honorable Chief Justice as the president of the court. The Deputy Chief Justice is to deputize the Chief Justice and is also the vice president of the court. Article 171 of the Constitution establishes the Judicial Service Commission, or the JSC, as one of the Chapter 15 commissions. The Honorable Chief Justice in JSC is the chairperson, and in this scenario, and unlike the constitutional architecture in Articles 161 and 163, the Honorable DCJ is not the vice chairperson of JSC. Running alongside the foregoing are the functions of the Chief Justice and the Honorable DCJ as provided for in Section 5 of the Judicial Service Act. The provision states as follows. This is in respect to administration of the judiciary. I do not need to read through all that. I proceed to say that the decision in Lena Conchela also dealt with the definitions and various types of deputies, and ultimately rendered itself in the following manner. I think this one I should quote. But paragraph 77, it says, it has been canvassed before us that where the Constitution intends the Deputy Chief Justice to act on behalf of the Chief Justice, it has expressly stated so. Specific examples cited were Articles 141.1, 144.4, 148.4. These provisions fall under Chapter 9 of the Constitution that deals with the executive. This chapter does not have a general provision as regards the deputization of the Chief Justice by the Deputy Chief Justice, as is provided for in Article 161 to be in Chapter 10 of the Constitution on the judiciary. Hence, the provision of the deputization of the Chief Justice in Chapter number 9. A holistic and purposeful interpretation of Article 161 2B of the Constitution and Section 5 of the Judicial Service Act leads us to the conclusion that the Deputy Chief Justice substitutes the Chief Justice where necessary. End of quote. In the end, the learned judges found and held that the constitutional function of the Honorable Chief Justice to assign the benches under Article 165 for the Constitution being an administrative function, can be performed by the DCJ when the DCJ is for good reason unable to perform this function. On our part, we have carefully addressed our minds to the issue. We find that there was a deliberate scheme by the drafters of the Constitution for the Honorable DCJ to deputize the Honorable CJ as Deputy Head of the Judiciary and as the Vice President of the Supreme Court, but not in the JSC. Such was an emphasis on the various manifestations of the constitutional duties bestowed upon the Honorable Chief Justice and the Honorable DCJ. As such, the prevailing legal position is that the Honorable DCJ can deputize the Honorable CJ in discharging judicial functions and in the administration of the judiciary as an arm of government, but cannot do so in respect of the affairs of the JSC. Our attention has also been drawn to the provisions of Article 259, Sub-Article 3B of the Constitution, which states as follows. This refers to construing the Constitution, and Sub-Article 3 provides as follows. Every provision of this Constitution shall be construed according to the doctrine of interpretation that the law is always speaking, and therefore, among other things, B, any reference in this Constitution to a state or other public office or officer or a person holding such an office includes a reference to the person acting in or otherwise performing the functions of the office at any particular time. Emphasis, or otherwise performing the functions of the office at any particular time. The above provision creates three tiers in which constitutional functions can be exercised. That is, by the substantive office holder, or by a person in an acting capacity, or by a person otherwise performing the functions of the office at any particular time. In our understanding, and against the background of the doctrine as stated, the drafters of our Constitution were deliberate about ensuring that the administration of duties and the application of the constitutional provisions are continuous and seamless, recognizing the necessity for offices and their functions to be performed even in transitional or extraordinary circumstances. Such an interpretation avoids technicalities and vacuums that would disturb the functioning of state offices or public institutions, thereby promoting administrative efficiency and upholding the principles of constitutional governance. The provision reflects the broader principles of the rule of law and good governance, which require that state and public offices continue to function effectively, even during periods of transition or when the substantive office holder is unavailable. It in turn promotes legal certainty and administrative efficiency by ensuring that all constitutional responsibilities are carried out without disruption. For this reason, the functions of Article 165, Sub-Article 4, in our view, and in as far as the same relate to the office of the Chief Justice, also includes the Deputy Chief Justice acting in the capacity of the office of the Chief Justice or discharging its functions in an interim, acting or auxiliary role. At this point in time, we also wish to point out that the Honorable Chief Justice empaneled this very bench on the 14th day of October 2024 to deal with 6 constitutional petitions that inter alia challenged the first petitioner's impeachment process in the National Assembly. The said petitions are still current. On the 18th of October 2024, the Honorable DCJ empaneled the same bench to deal with constitutional petitions challenging the impeachment of the first petitioner in the Senate. To us, it is beyond peradventure that the Honorable DCJ can assign judges under Article 165, Sub-Article 4 of the Constitution, whenever he or she is discharging any of the constitutional functions on behalf of the Chief Justice. In this case, we do not find any fault in the Honorable DCJ assigning judges to sit in this bench, more so when the Honorable Chief Justice has not raised any red flag. Thank you.
Right. I will deal with a question of other related issues that came up during the submissions of the application. Besides the issue of the benches and panelment by the Deputy CJ, several additional issues have been raised. The bench found it necessary to address these issues so as to ensure both the completeness of the record and finality in the issues raised. During the submissions, an issue was raised concerning the directions issued by the three-judge bench and the transmission of the files in Nairobi Petition E565 of 2024, Kerugoya Petitions E013 and E014 consolidated, as well as E015 of 2024. A review of the CTS, that is the case tracking system, confirms that the petition in E565 of 2024 was filed on the 18th of October 2024 at 8 o'clock p.m. Later that same day, approximately 5 hours on, at 1:51 p.m., Justice Chacha Muita dealt with an application filed under certificate of urgency which had been submitted alongside the petition. By 5:33 p.m., roughly 3 hours after the earlier application, a notice of motion application dated the 1st of October 2024, was dated the 1st of October 2024, was filed, this time by the respondents seeking the following orders. 1, that the application be certified as urgent and service of the application dispensed with in the first instance. 2, that pending the hearing and determination of further application, inter partes, this honorable court be pleased to set aside, vary, or review the orders issued on the 18th day of October 2024, that is the interim conservatory orders. 3, that in the alternative, this court be pleased to set aside, vary, or discharge the ex parte orders issued on the 18th day of October 2024, and 4, that this honorable court will issue any other orders it deems fit in the interest of justice. Following its empanelment on the 18th of October 2024, and having received directions from the Office of the Deputy CJ, the bench deliberated on the appropriate directions to be issued. On the 19th of October 2024, at 12:20 p.m., the bench issued the following directions. That in light of the urgency of the matter and the weighty issues raised therein, we direct that the application be served and responded to forthwith for hearing inter partes on Tuesday, the 22nd of October 2024 at 11 a.m. in open court number 18. Petition E013, on the other hand, was filed on the 25th of September 2024 at 8:33 p.m., while petition E014 was filed on the 2nd of October 2024 at 7:07 p.m., both way past official working hours of the court. The CTS will further show that an application in E014 was filed on the 30th of September 2024, and directions were issued on the very same day, although the matter was not certified as urgent. Subsequent directions and a ruling issued on the 11th of October 2024 resulted in the consolidation of petitions E013 and E014, followed by an order for empanelment. As the record on CTS will further show, the directions issued by the court in E014 of 2024, which were issued on the 2nd of October 2024, were again issued at 6:22 p.m., which is outside of what one would call the routine working hours of the court. This was due to the urgency demonstrated omitted in the application, which sought directions regarding the then ongoing public participation process. The bench takes great exception to the petitioner applicant's conduct that when favorable to them, issues of orders, or rather orders issued outside of what one would refer to as the normal working hours of the court raise no concern. However, when the court acts in an instance where it has been moved by any other party and likewise proceeds to deal with an application at hand, the applicants show their indignation. Moving to petition E015, the CTS again would show that the same was filed on the 18th of October 2024, and once again following the directions issued by the court, this bench was empaneled on the 18th of October 2024 to hear all the three petitions, that is E565 of 2024, E013, E014, and E015, all of 2024. From this sequence of events, it is notable that the interaction between counsel and the courts on an almost real-time basis is not novel, and is in fact a practice that counsels are well familiar with. The CTS enables both counsel and the court to operate in real time, transcending traditional time limitations. This fact also buttresses the argument that with the advent of the CTS system, it is not unusual for courts to issue directions within the filing of an application or outside of what once again would be referred to outside the routine work hours of the court when circumstances do so require. Moreover, in raising the issue of improper seating, the applicants omitted a crucial fact, which was that the court had been moved by the respondents in petitions E565 of 2024 and E015 of 2024. As such, the court did not convene suo motu, but rather in response to the applications before it. The applicants have repeatedly referred to this convening as a sitting of the court, a term that we feel as a bench requires clarification and demystification. It is a matter of judicial notice that since the onset of the COVID-19 pandemic and the introduction of the case tracking system, the tradition of dealing with certificates of urgency has since evolved. Allow me to quote the practice direction number 19A of the High Court Practice Directions of the 11th of January 2022, which states as follows: that applications filed under certificate of urgency shall be considered by the judge, we emphasize here, at the earliest opportunity. While the practice directions also stipulated that applications filed after 12 p.m. may be considered the next working day, the full adoption of the e-filing system across the judiciary has likely rendered this provision obsolete. Applications are now processed almost in real time, a fact well known to the justice users across the country and which we have demonstrated in this room. Furthermore, practice direction 19B confers discretion upon the court to issue orders or directions without the attendance of advocates or parties. This implies that the court can indeed issue directions on an application without the need for a formal sitting. The relevant provision, once again, reads as follows: that the court may, in its discretion, issue orders, stroke directions without the attendance of the advocates or parties. In this court, rather in this case, the issue has been raised that this court allegedly served and considered an application by the respondent on a Saturday outside of their official court hours. The ordinary definition of a sitting as provided in the Black's Dictionary is a formal occasion when the court convenes to conduct its business. In this instance, no such formal sitting occurred. In this instance, I repeat, no such formal sitting occurred. Rather, the bench merely conferred and issued directions electronically as expressly permitted under Practice Directions 19B. This is markedly different from a court session in which the bench is convened to hear and determine a matter. Furthermore, no evidence or proceedings have been presented before this bench to support the claim that a formal sitting did take place. Accordingly, it is only fair and reasonable for the parties to dispel any notion that this bench convened to hear arguments from any party ex parte before issuing directions. No such formal sitting took place, the court again emphasizes, and directions were issued electronically in line with established practice and procedural rules. We do, however, recommend that the current practice directions and relevant statutes, such as the High Court Organization and Administration Act, be amended so as to provide a much needed further clarity on this subject. Moreover, for the avoidance of doubt, and out of all the prayers sought by the respondent, only prayer number 1, which sought to have the matter certified as urgent, was granted. No other reliefs were considered or granted at the time. It is evident that the court was fully cognizant of both the urgency of the matter and the potential repercussions that granting any further ex parte orders could have had on the prevailing status quo. With this understanding, and in an effort to balance the scales of justice, the bench issued the directions that are now being charged. We hold the view that there was nothing unconventional in the manner in which this bench dealt with the 2 applications filed under certificate of urgency. As regards the arguments that directions had already been issued by the respective courts for a mention before the bench on the 24th of October 2024, the arguments by the applicants appear to insinuate that the bench ought to have retained the date. For clarity purposes, this date had not been given by this bench, rather this date had been given prior to the empanelment of this bench. However, upon empanelment of the bench, the applications under certificate of urgency, the ones that I have just referred to, were filed, which applications were dealt with, and we feel rightly so. Being seized of the matter, it is our view that the bench retains the discretion to issue appropriate directions depending on the developments and in light of its mandate as it did, having been moved by a party under certificate of urgency. With respect to the claim that was raised on discriminatory transmission of files to the bench, it must be emphasized that this bench has no role and no control whatsoever in the administrative processes that occur prior to its empanelment. Concerns have been raised about delays in the transmission of certain files, but it is crucial for us to clarify that the term transmission in this case may not necessarily refer to the physical transfer of documents. In the context of judicial processes, particularly with the advent of digital systems, transmission may very well refer to the electronic movement or assignment of case files We say this on the strength of the fact that with the CTS, all file documents are available in real time across the judiciary, eliminating the need for physical file movement. Let me refer once again to practice direction number 41A Roman 2, which provides that advocates and litigants shall have access to court information electronically. While this court cannot and will not speculate on the causes of any delays in file transmission, the bench nonetheless finds no basis for concluding that such delays amount to any form of procedural omission on the part of the bench, as no such evidence has been presented. Applicants have equally in their submissions attempted to cast aspersions on the proceedings of this court, some of which I have already referenced. That is that the court was convened on Saturday, stating that there is no urgency in this matter, and so there was no need to convene the sittings of the 22nd day of October 2024, that this matter is being given priority over other petitions which have been filed, an insinuation that the bench is part of a conspiracy to infringe the petitioner's Article 50 right to fair hearing, and what I have again alluded to, that the transmission of the files from the Kiroboya High Court took place with what has been referred to as a supersonic speed. One of the counsels went further by intimating that an exercise akin to the radical surgery may well be forthcoming, a statement which the bench, with tremendous respect, perceives as a veiled attempt at intimidation. The bench feels that such remarks are regrettable and wholly inappropriate. This bench remains firm in its duty and will not be swayed or influenced by any form of intimidation, regardless of its source. The bench takes the view that the applicants appear to selectively focus on aspects that favor their position while conveniently disregarding that declines that the applicants are presently benefiting from final conservatory orders, which this bench did not indicate to lift. Despite having obtained final conservatory orders, as the court has already observed, it is now apparent that the applicants no longer perceive the urgency in this matter. Instead, they seek to cast aspersions on this court for addressing the matter with the necessary expedition. Such conduct is contradictory and undermines the very urgency that the applicants had initially invoked. The bench notes that the issues raised in this petition have, on various occasions and before different judges, consistently been certified as urgent and as involving substantive constitutional questions. This underscores the gravity and significance of the matters at hand. One of the counsels again insinuated that this bench is part of a conspiracy to violate the petitioner's right to a fair hearing under Article 50 of the Constitution. The bench finds that these submissions are without any foundation and wholly without merit. This court has not issued any rulings or directions that would suggest such an intention. It is apparent that this argument was made for the sake of the gallery, and we find it unnecessary to therefore address it further, save to reaffirm that this court remains fully committed to upholding the Constitution and the rule of law. In conclusion, we do find and hold that the accusations made by the applicants against this bench are entirely without merit. On this out of the limb is whether the matter raises issues of public interest which require expeditious disposition of the petitions. The applicants have urged that the applications before the court are not urgent and have loudly wondered why it was necessary to give directions for hearing of the applications on the 22nd day of October 2024. In response, the bench quotes Article 131, which establishes the office of the President and the office of the Deputy President, and also we have cited Article 147 with regards to the functions of the Deputy President, just to lay context. And the context is this, according to the bench, that the first petitioner has been impeached under Article 145 of the Constitution, marking the first instance of such an event in Kenya's history. The impeachment of the said petitioner has undoubtedly garnered significant public interest, and these court proceedings represent a direct challenge to that impeachment. It goes without saying that these legal proceedings are of paramount concern to the citizens of this country. To suggest, as the applicants have, that this matter lacks urgency and does not warrant prompt adjudication is disingenuous and dismissive of its far-reaching implications. We have taken the liberty to define the term public interest in the Black's Law Dictionary, and you will also find the Supreme Court of Kenya's definition of public interest in the case of Stephen versus Orozco, which permit me not to get into. Safe to say that from the foregoing, a matter is of public interest if the holding on law affects a considerable number of people in society, if the holding in law involves government and or government agencies, if a determination of law affects the proper functioning of public institutions of governance or of the court's scope for dispensing redress, and if the holding of law affects the mode of discharge of duty by public officers. These proceedings, in our view, as the bench, raise enormous public interest, and it is in the interest of the public that these proceedings are heard and finalized most expeditiously. Therefore, the aspersions cast by the applicants concerning the directions for the hearing of the applications before the court on the 22nd day of October 2024, in our view, lack basis and they are dismissed.
This position, having carefully considered the application, we are satisfied that the prayer sought herein must fail. Nonetheless, as indicated in our ruling, there is a pressing need for a clear practice directions regarding the procedure and the process for handling virtual and online directions and proceedings. We commend the applicants as this application has illuminated the necessity for such guidelines and made the issue more apparent. As such, we hereby direct the Honorable Deputy Registrar of this division to transmit a copy of this ruling to the Honorable Chief Justice. Before we conclude, the bench wishes to once again emphasize its unwavering commitment to objective neutrality in this matter. We assure all parties that their right to a fair hearing remains fully safeguarded. The bench, acting in fidelity to its oath of office and in strict adherence to the dictates of the Constitution, remains resolutely committed to the fair and just determination of the issues before it. Finally, the application dated 22nd of October 2024 is disallowed with cause in the course. Leave to appeal is hereby granted. Certified copies of these proceedings and rulings shall be availed upon payment of the requisite court fees as the case may be. That's the ruling of the court.
But on behalf of the petitioner, we have listened to the ruling. We have have got no problem with the feasibility of it one way or the other. We leave it to our clients, the decision of whether or not they will appeal the ruling, largely because of a number of instances where words have been put into the mouths of the petitioners that were never uttered.
Leave to appeal is hereby granted. Certified copies of those proceedings, these proceedings and rulings shall be availed upon payment of the requisite court fees as the case may be. That's the ruling of the court.
My lord.
My lord, on behalf of the petitioners, we have listened to the ruling. We have got no problem with the feasibility of it one way or the other. We leave it to our clients, the decision of whether or not they will appeal the ruling, largely because of a number of instances where words have been put into the mouths of the petitioners that were never uttered. Be that as it may, I believe since we received some communications from the Deputy Registrar, and there were certain other pending matters in the files that were under consideration, we shall await the directions of the court before, from the petitioner's point of view, we can say one or two things. I do not know whether Afisis as my learned senior from the committee has anything to add.
My lords, your leadership, we appreciate that this honorable court of its own volition has granted leave to appeal. Speaking for myself, obviously the decision is that of the client. So I will be advising the client, but it is for the client to make the final decision. But in fairness to me as counsel and other counsel on this bench, I will certainly be seeking to persuade my client to appeal. One issue of accusing counsel to have been talking to the gallery, that is not something that should be left on the record of this court. It is damaging to counsel, and that is an issue that definitely needs to be taken out of the record of this court by the Court of Appeal. It was a very unfair position.
May it please the court, on behalf of the respondents, we thank you for the time and nature of the delivery of that ruling to allow this matter to proceed. We note that you have permitted the parties leave to appeal, and we support that. The respondents support a fair resolution of this dispute in accordance with the law. Therefore, we would not oppose their right to appeal. Having said that, however, and in reference to my learned friend, Mr. Kibe Mungai, who has alluded to other petitions pending before court, it is the respondent's position that we should exhaust all matters today relating to the matter that has been called out by your clerk or your legal assistant. I apologize to the lady, so that we may exhaust that, after which the court will give directions on any other matter that may be before you or may be anticipated to come before you. We thank you. My
Lord, my lady, on behalf of the National Assembly, I wish to express our gratitude for the very clear ruling that the court has delivered this afternoon. The ruling has dealt conclusively, not just with the matters that were contained in the application that was hurriedly filed and responded to yesterday afternoon, but indeed some of the other peripheral issues that the petitioners unfortunately took a lot of court time yesterday to deal with. My lords, my lady, the National Assembly has filed an application dated the 18th of October 2024. And I believe that application was referred to in the ruling a few moments ago. That application, subsequent to the ruling that you have just delivered, I submit is the next issue that the court should deal with. And just to put it on record, my lord, that we are ready to proceed with that application this afternoon. Members of the court will recall that last week on Tuesday, on the 15th of this month, at an hour not very different to this, when it suited the petitioners to have their application for conservatory orders heard, they insisted on it being heard. And we request that the urgency in this matter remaining and having been noted by the court, we proceed with the hearing of that application, which has been fully responded to, immediately after this. I'm most obliged.
My lords and your ladyship, further to that, for Senate, I wish to state, my lords and your ladyship, that unlike the petitioners, we are willing to argue the application in a record 30 minutes.
Is this the same application?
Yes, the application dated 18th October 2024. We will only ask for 30 minutes to exhaust our application. We will dive straight into constitutional principles. We will not take much time. The respondents can have as much time as they want so that this matter can be concluded. My lords, Mr. Kibe has talked about the gallery of Paul Muter Senior Counsel. From that side, it was apparent that they were not just addressing the court. They were addressing other matters.
Do we need let us not go into that.
Let
us not go into that now.
I will withdraw that.
Yes.
But my lord, we are ready to proceed.
No, we don't want you to raise something and then you say you withdraw it. You know, after causing the damage, withdraw properly.
I will withdraw the remark that the petitioners are addressing the public gallery today.
My lord, with your permission, my lady, yesterday we were barred from being part of this proceeding. We have seen communication that we are now legally here. We have stopped mourning. Could we be allowed officially by these files being called so that we are together? We still feel that we are excluded when we are before you.
In which petition? In which petition?
There is petition file E570,
okay.
E550, E549.
In E549, and associate myself with the submissions made by my learned senior counsel, Paul Moite, and the ones made by my learned friend, Senior Kibe. Your Lordship, to the best of our knowledge, in the matter E015, when we broke yesterday, there was a promise by the court, and the court has kept that promise, that we shall be coming for a ruling of the application that was made. Yesterday I indicated to the court, Your Lordship, that this court was constituted to deal with the consolidated petitions E522 consolidated, and now E565 consolidated. And we have been issued the notice that my friend Mr. Omari is referring to, that he also seized of 4 other matters: E570, E550, E541, and E572. Your Lordship, the notice that was issued to us indicated that we are coming for a mention in respect to those particular files. I hope the court is in possession of this notice, so that the court may refer to the same. Subsequent to which, Your Lordship will be seeking your guidance on how we deal with the applications filed therein. For example, pursuant to my client's instructions, we filed an application dated the 22nd of October for the recusal of the bench. We would wish that subsequent to the court addressing and acknowledging that there are other files before it, that I get directions on how to dispose of my application, for which, Your Lordship, the application was served. I wish to take directions exclusively and specifically on that particular matter.
My lords, may it please you, I hate to interrupt, but this is most unforeseen. We are all counsel of some reasonable experience. We all appreciate, some of them here are very senior advocates, very senior counsel. The file before the court is the only file in which you can make an application. The court cannot make orders in files that are not before them. All these files physically brought to the court are not before court. They will be before court when they are called out by your legal assistant as being available for the court to make orders. We therefore object to this manner of conducting these proceedings. It is our very humble submission that it is yet another attempt to delay the expeditious disposal of this matter.
Your Lordship, very
My Lord,
briefly.
if I may, my Lord.
Yes.
There are matters that you have certified as urgent and that you have identified as being urgent. And I say this with a very heavy heart. My learned colleagues for the petitioners have been engaging in this dilatory tactic since yesterday. There are 2 applications before you that are certified as urgent. There are several other matters that have applications that perhaps have not been certified as urgent. Perhaps your lordships may be kind enough to deal with those urgent applications, and these matters can be dealt with later on. The files may be here, but they are not before the court.
Your Lordship.
Okay, you have talked enough.
Counsel on this side may have.
Yes.
Counsel on that side appears to be taking the whole of it.
Because they stand much. Just speak, Mr. Mwite. If you want to be heard, just speak. We'll listen to you.
I'm asking
Yes.
for equity of power. More time to counsel on this side.
They stand and speak. You also just stand and speak. We have not stopped you from standing. Yes, speak.
I think for purposes of clarity, yesterday when we started hearing on the issue of validity of the bench, which has now been disposed by the ruling in red, the question that we wanted was the application for the validity plus the issue to do with the recusal behind together. The understanding of the court and ourselves was that they cannot be dealt with together. So that the second preliminary issues after the issue of the validity of the bench has been disposed of are the 3 pending, are they 3? Actually, I don't know about it. 3 applications for recusal. Those are preliminary issues and they relate to the same consolidated matters that this court has given a ruling on. That is issue number 1. Issue number 2, my lord, that is important to be noted. Yes, the consolidated file that is before you has that applications for recusal. That's what my learned colleague is emphasizing. So the second business of the court was supposed to be that one. But more importantly, my lord, so that we do not want to hear these accusations about somebody is trying to delay this matter. We are the victim, and I reiterate that. For purposes of the petitions before you, we would like this petition had as a solicited. And we kept on saying yesterday, the petitions to be had. My lord, these rules, because it's the enforcement of the constitution, the Mutunga rules applies. since the Mutunga rules applies, the applications of the Mutunga rules was everybody was supposed to respond even to the petition to get the matters rolling. There have been no compliance with Mutunga rules for purposes of the respondent. So that if anybody was to be accused of any delay, it would be somebody who has not complied with the Mutunga rules. That is issue number one. Issue number two, my lord, was this, that even for purposes of consolidation, the consolidated matters, some of the advocates led by my colleague, Mrs. Kimogo, they were not even served with the applications that the respondents are itching to have them disposed of. So that, my lord, because of that mess that was created as of yesterday, and the fact that we do have now a notice talking about these matters, the truth of the matter is, unless we have a situation where some of the advocates in the four matters that were not there yesterday have not even been served with this notice, and I know them. So that unless now we take a fresh date without somebody waiting to say that, oh, this court must discharge orders and we have a swearing in over the weekend, the truth of the matter is we need a clear date where the court ensures everybody who ought to be before you, particularly based on these issues that has been raised courtesy of correspondence with the Chief Justice, is addressed. But somebody to pretend, oh, I want to lift the conservatory order and the other side is delaying, it is unfair. We want the petition heard, and it starts with compliance with the Mutunga rules, which there is no compliance whatsoever by the respondents. So that, my lord, I beg you that let us not appear now to be saying, oh, somebody is playing to the gallery. Nobody is playing to the gallery. We just want to assert everybody's rights. And these rights are very easy to enforce if the Mutunga rules are going to guide these proceedings. My lord, I beg you to have the information of that.
Your Lordship, I had just wanted to highlight the content of the notice which you received.
I think we'll talk about the notice. I said, let's sit down. We want to talk about that notice. I will talk about that notice before you speak.
My Lord, do I have your permission to address the court?
And even if the court wants to talk, you don't want the court to talk. Dr. Camino, let me address the issue of the notice.
Oh, sorry. I apologize.
Please.
I apologize.
I think we have made it very clear in the ruling which I have just delivered that the matters before this court are very important to the people of this republic. And you will appreciate that petitions are still being filed throughout Kenya. When we retired yesterday, we received several empanelment of matters of which we gave this notice. Therefore, don't think you are the only person who are in these petitions. There are also other Kenyans who are coming day in, night out. So the matters which you've set out for mention are the matters in which we have been empaneled as from yesterday. So you wait for court to give directions, then you start talking. You cannot just start talking from the air without facts. Let us mention these files first, then from there you'll see the directions emerging, and then you can make your prayers. Let's mention these files first. The other clarification is that we have two cohorts of petitions which have been consolidated. The first cohort were the petitions which were filed to challenge the processes both in Parliament, yes. And during that time, this bench consolidated 6 petitions, with the lead petition being 522 of 2024. Is that correct? That petition, number 522 of 2024, is the lead file in the petitions which were filed before the finalization of the matters in the Senate. Then, after the proceedings in the Senate, other petitions were filed. And with you, we consolidated all those petitions yesterday. So we have two running parallel petitions before the Senate proceedings and after the Senate proceedings. You will remember that petition number 522 was, we listed it for a mention on 29th of this month. But because of need to know, because I know there could be cross-cutting representation in these petitions, we decided just to call it because we knew that all of you would be here, so that if there's anything you want to say on those petitions, you can say it. So that's the reason why we have petition 522 here for a mention. There's nothing to be mentioned, but we said since parties are likely to be here, and some of the parties were even asking for it yesterday, so we brought it. But the other petitions to be mentioned are specific petitions where we have been empaneled. And we wanted to find out the way forward, whether we can consolidate these petitions or whether they can be done separately. So these are petitions number, let's mention petition number 570 of 2024, AD by Guru and Victor Gatia. Yes, this petition.
My Lord,
Excuse me. Where are the quorums? Put quorums in these matters. Just a minute. Yes.
My Lord, in this petition, this one was filed by the law firm of, I believe, Mutembe and Maret, it's called what? Mutembe, Gachagua and Company Advocates. I am aware of this petition for the simple reason that he had requested me that when it comes to the hearing, I appear alongside him.
Alongside who?
Mr. Mutembe Marete. My Lord, the parties are many, starting with the first respondent, that is President Ruto, regarding Gachagua is the second respondent, and there are others. My Lord, for purposes of this petition, it was filed on Friday, and by Judge Mamuye, referred it to the Honorable the Chief Justice, and we expected it to be coming tomorrow on Thursday. My Lord, Mr. Mutembe was not served with this particular notice that is before you.
Actually, nobody was served. We sent out the notice in the morning today because we received them in the morning. And that's why I said that this matter has kept on coming.
Yes.
And because the representation is likely to be across, we mentioned them because we thought we'd find people like you waiting for them here.
Waiting for them here.
Yes.
So that, my Lord, in that case, what I would ask the court, and for the additional reason that I am aware that in that matter, the notice of motion is seeking a 5-judge bench, and particularly for the reason that this is an application by the citizens of Central Kenya who says, like in the year 2013, that their rights, not just regarding Gachagua, have been affected adversely by the impeachment of the Deputy President Gachagua, and therefore I would ask that this matter do come tomorrow so that the issue on that issues of empanelment and in the presence of Mr. Mutembe can be dealt with. Because now that it is obvious that even the direct, like the advocates who filed the case are not here, it would only be fair that there is another mention where they can also be there. Actually, we didn't even have the file. We are just looking at it from our record. But that is the position as far as 570 is concerned. There is a specific application for a 5-judge bench in that matter.
Mr. Kibe,
yes, my lord.
We are beyond that. There was a request for a 5-judge bench.
Yes, my lord.
But what has been empaneled is a 3-judge bench,
yes,
comprising Justice Eric Ogola, Justice Mrima, and Honorable Dr. Justice Freda Mugambi. So the request for a 5-judge bench, I think, is overtaken by events unless he wants to appeal.
Yes. The chances of appeal are very high. for the simple reasons, my lord, that will become apparent. I believe there must be some mechanical applications to the issues, but now that it arises specifically, that issue would be addressed, and the Chief Justice would have the relevant communications tomorrow morning, while given the nature of the issue that must be dealt with, there must be a 5-judge matter. All benches can be expanded. I believe that is the positions that we are coming from. So without saying specifically that we don't want anyone, all benches are capable of being expansion, particularly bearing in mind, and this is something that a number of the clients that already we are representing, there have been repeated insinuations by our people out there, including Senior Counsel Abdel Abdullahi, that the senior bench is supposed, the 3-judge bench is supposed to do this or the other. We can't help that. This is not.
So what we'll do, Mr. Mugai, is that we'll mention this matter tomorrow
yes.
At 9.
Most obliged.
Mr. Kibe, you will serve.
Most of the people actually here, we have served them, but you shall serve the notice of hearing.
All right.
The notice of hearing for the mention tomorrow at 9. I thought my Lord the 10 would have been in here, because by the time I go to my office, there will be no opportunity to do some of this.
You know, by the time we spend here means that even if you come at 10, you'll find us here.
My Lord, what time then do we come tomorrow?
The court starts at 9.
Yes.
You can come at 11.
11. What?
Yes.
My Lord, I am asking, please, in this particular file, that you record my presence together with the other lawyers I mentioned earlier as appearing for the Deputy President with the second response.
This one?
Yes.
The verified?
Yes.
But you didn't stand up, Mr. Mute. I thought you were not here. This matter of 570?
Yes. If you look at the party, the Deputy President is the second.
Okay. Okay. So you agree with the directions which you have given, eh?
I accept directions. And I will be here tomorrow, I think. Inshallah.
Yes.
Mr. Lordship, with this particular matter.
Let's the same matter.
Yes.
570.
Yes, my name is Manzo. I'd wish to go on record for the first interested party.
Your Lordship, my lady, may I be placed on record for the second and fourth interested party? and permit me to only indicate the implication of the orders of the empowerment that were issued by the judge who directed the Chief Justice that empower you. To the best of my thinking and knowledge is that the prayer was granted as it is for the empowerment of 5 bench. 5 judge bench.
Mr. Jiru, yes. We speak from the record. You heard me mention the parties. I said that this file has been empaneled to comprise the Honorable Mr. Justice Eric Ogola, the Honorable Mr. Justice Murima, the Honorable Dr. Judge Freda Mugambi. I think that's very clear. We are only 3.
That's correct. But we'll address it tomorrow on that issue.
My lord, my lady.
So we mention it tomorrow. Mr. Njiru, you say you come for which parties?
Your Lordship, I appear for the 2nd and the 4th interested party.
Thank you.
My Lord, perhaps if I may make a request. My Lord, there is a file that is live in both. And that is petition number 565 of 2024. We have requested, my Lord, that you give directions in respect of the applications in that matter, because this process of taking quorum might take some time. And there are 3 cohorts of files that are before you. And if I may just be given a moment to explain myself. As the court has correctly identified, there is a cohort of files that are consolidated in petition 522. There is a cohort of files that is consolidated around petition 565, which have the 2 applications that the court has identified as urgent. And then there are these others that have been referred to the court by virtue of the email that we have all seen today. It is my request that the court keeps them in those cohorts so that the applications are able to be dealt with because they are urgent. These are important, but the applications are urgent. And the court has identified that urgency because this will go on for 2 or 3 hours without any directions having been given in 565.
What could we be on board together? We are being made orphans. The state is in the bedroom. Let us also be in the bedroom so that we can respond.
Mr. Amari, what do you want to do in the bedroom?
We will discuss the construction of our plan. Can we allow the parties?
Mr. Nyamodi, the reason why we are mentioning these matters is to find out if any of them would be ripe for consolidation with the matter which is here so that we don't duplicate.
Thank you, Lord.
My Lord, perhaps as you consider that, let me put it on record that if you are considering whether they are ripe for consolidation, the consolidation should not then slow down the hearing of the application that you have already identified as urgent. If they are to come on board, they come on board and proceed from where we are.
Let us be on board first. We will respond to you appropriately.
Okay.
Allow us to be in the early stage platform.
Give me the next.
My lady and my lords, I just have a passionate plea. There are not many places. The first place is we consider utilizing the ceremonial court on the ground floor because it is spacious. It's sufficient for all. That's number one. Number 2, my request is this. The court has all the petitions. Why can't the assistants to the court enumerate the parties there in the quorum in the manner we used to do in the Court of Appeal before? So that when we appear here, whatever time we indicate, we'll just fill our respective names and the court will be able to deal with the matter without the need of this backup. Number 3, my lords and my lady, I think the court needs to just be a little bit proactive. When you retreat, you may make 2 decisions. One, they either determine the interlocutory applications, in which case you can frame issues for the parties to submit. Or 2, if you're minded to hear the petitions themselves, then still frame the issues and respond it to us so that we are able to make progress. That way we make good use of the issue time that is very limited. I receive you.
Thank you, Mr. Harvey. Well taken.
As a former chairman of the Council Science, let me second the first issue and plead that if only for the purposes of everybody getting sufficient oxygen, because we are too crowded and the people want to listen, and the media and the members of the public, if it is possible, let us use the ceremonial hall.
Council, Senior Council, we will use the ceremonial hall as from tomorrow.
Thank you.
And
Yes, I wish to say that perhaps when giving directions, then and if parties, files are going to be consolidated, then it would be proper each person is served with the applications so that we are able to respond, even if we are given a day to respond, so that when we begin to submit, we are able to submit according to the law, not as per the bar and whatever issues are being raised. Thank you.
Thank you.
My Lord, I was going to beseech the court, if we are to make progress, I'll beseech the court to invoke its powers under Section 55, Article 159. We will go on and on. There is no shortage of legal provisions enabling this court to rein in on the lawyers. Because if you don't do that, my Lord, on a matter like this where you have 20 lawyers, 50 lawyers on the other side, we will be coming to you. We'll be doing legal gymnastics, legal ping pong, what I call legal sophistry on other occasions. And meanwhile, we'll be lamenting as we are now lamenting to you. So there are applications, both from this side and this side, certified agent. Meanwhile, we are spending a lot of time, each of us from whatever side, studying to raise this or other housekeeping issue. I beseech you, my Lord, in a matter like this, the court must be very firm. It must run the council. The court itself must have very clear directions. Which is the application that will be had, in what sequence, what are the time allocations, how the parties share those times.
We have agreed on that, and what we ask is let us mention these matters so that we know how they relate to the other matters which are before the court. So we have mentioned 570. We have mentioned, do you have 570? We have mentioned 570. There's, which one did we mention?
We are mentioning 5.
This 550. 550.
In E570.
We have mentioned E570. E550, Speaker of the National Assembly versus Brigadier Gachagua.
My Lord, this file is already consolidated under the cohort of 550.
$550.
When was the petition filed?
No, sorry, my Lord, that was not.
Yes, 550. Who is in 550? Who is in 550?
My Lord, mine is 572.
I'm asking 550.
Yes, my Lord, in 550. We remove my Lord with we appear for the first respondent.
I guess he can tell us who is the petition.
The petitioner, my Lord, is the former Deputy President, my Lord. Represented by my Lord Senior.
Well, I appear for the Deputy President, not former. He remains in office on the basis of the conservatory orders and each bench has confirmed weighted issue, which is why we are here. Let's not join the rush.
For the first petition, eh?
For the first petition. I thank you.
My Lord, if it pleases you, Nyamodi and Gumbo for the second respondent. And our learned colleague, Mr. Murugara.
Yes.
In that matter, my name is Mukele. I appear together with Ms. Tanji and my senior professor of gender for the third court respondent.
Yes.
That's all.
Who else is in this matter? So, for the petitioner, Mr. What are the issues in this matter? Are they relevant to the consolidated petitions?
The petition example. Yes. There are so many files here.
This is
the same team of lawyers.
Yes.
Including myself that I gave when we came for the ruling.
Yes.
Is appearing for the deputy president.
But what I'm asking is it going to be consolidated or is it standalone?
It's one of the ones that we are consolidated.
No.
Yes, speak, please.
For you to be able to progress, I beseech you that don't this matters tomorrow. Go and make directions. You're either hearing the petitions or the applications. Come here so that we have a perspective of what we do. Otherwise, you will not.
We are alive of that fact, Mr. Harvey, but it is the councils who will be saying that their right to be heard, even on petition, even if the slightest issue has not been granted. Therefore, let us agree on the way forward. If you make a proposal can come from your side, how you want to deal with all these petitions. Is it possible that you want to ignore all applications and proceed to the petitions? You can make a submission which this court can consider.
My Lord, if I may, just to guide the court, and on this account I will do it as senior counsel. My Lord, there are urgent applications before you. The applicants or the petitioners at their bite yesterday on a preliminary objection that the court has ruled on this afternoon. My Lord, we have an urgent application that was filed before you, dated 18th October 2024, for discharge of the conservatory orders. Whatever decision this court makes, it can be either way, will lead to directions on the hearing of all the consolidated petitions. Some of the petitions, my Lord, deal with issues or causes of action that arose before, my Lord, the impeachment. The proper position of the law is that the party who is the petitioner is the former deputy president. That's the position of Article 145(7). Allow us, my lords, to urge our application for the setting aside of conservatory orders. I think, my lord, that's the only way we can move, because they have had their bite, let us have our bite as well. We will only take 30 minutes, we request.
I'm not disagreeing with you, Professor Gianda. What I'm saying is that let's mention these files.
Yes.
We are on the third one, and if you have not been interrupting, perhaps we'll be through with them. 550, I've recorded the quorum, and what I asked, is this file related to the files before the court? For the purposes of consolidation, or it can stand alone?
Can we deal with that? We're not to go. We only do it.
Because there is a...
Consolidation has implications. I need to consult my team. I need to consult the client. Let's take the quorum Let's deal with the consolidation.
So we mention it tomorrow.
Yes.
Next. Uh, 541, Dr. Clarence Eboso. Dr. Clarence Oboso.
May it please the court. My name is Dr. Clarence Eboso. I'm the first petitioner in E541. The petitioner is between Dr. Clarence Eboso, Ms. Wanjiru Mwangi, versus the Speaker of the National Assembly, the Attorney General, and with the Law Society of Kenya as an interested party. The petition relates to the process of impeachment, particularly in the National Assembly, and seeks orders to quash the proceedings in the National Assembly. The petition has an application which was certified urgent and which sought an injunction against the entire proceedings of impeachment. The court which certified it urgent directed that the application would be heard by the bench that would be constituted. Several of the prayers that were made in the application have since been overtaken by events. However, the substance of the application sought to conserve the issues as they were, and therefore the conservatory orders that were issued by the court in protected some of the prayers that we had made in the application. Yesterday I pointed out to the court that proceeding with the discussions on the conservatory orders would have prejudiced us, because then we'd have lost out without participating. Our prayer would be
He's arguing the application. We are taking so long.
Just tell us, Mr. Clarence, whether this petition, you want it to stand alone or whether you want it to be consolidated with the petitions before the court.
That's where I was going to go.
Just go there, please.
We would be seeking that the petition be consolidated with the petitions relating to both the impeachment process and the filling of the vacancy that arises from impeachment. The reason being, upon filling of any vacancy.
Okay, we have heard you. You are agreeable to this petition being consolidated with the petitions which are in file number 565 of 2024.
My Lord, may I just conclude? My Lord, may I just conclude that I will be willing to compromise our application, provided that we can be allowed to participate in the applications for conservatory orders that are before the court, in the interest alleging time.
With your permission, my Lord, I appear for the first respondent.
Yes.
And my Lord, I note that we didn't come with our file.
Is this petition post-Senate proceedings?
No, my Lord. It has no relation with the post-Senate. It was filed, my Lord.
Before.
And it does not touch on issues, my Lord, that happened at the Senate. Ordinarily, my Lord, would be opposed.
So we mentioned this matter.
Tomorrow, my Lord.
We mentioned this matter on 29th when the petition number 522 will be mentioned.
Most of them.
Tomorrow or the 29th?
My Lord.
Yes.
I'm not sure if the court got the last statement I made. It would be greatly prejudicial to us if the discussions relating to the conservatory orders continue without our participation, because we are essentially raising the same issue in our application.
My Lord, I agree. We filed our application on the 8th of October 2024 before the National Assembly and even made its impeachment at impeached Deputy Brigadier Gachagua, my Lord. We are acting in person, we are laymen, my Lord, and we are also protected by the same laws, Article 27, Article 47, 48, and 49, and 50, my Lord, for the right to a fair hearing. So we do ask the court does mention our matter tomorrow so that we can articulate the points that we need to.
My Lord, I appreciate the fact that the petitioners are appearing in person. And my Lord, once the court has made an order, my Lord, the only remedy available to the parties is either to appeal, my Lord.
We have not made any order. You know, we talk before we make orders.
Sorry, my Lord.
So we mention this matter tomorrow.
Will be available.
We took. Which one in that?
I think
572. 572.
My Lord, the presiding judge, my Lord, my lady, doctor, it pleases you in the matter. My name is Wamboi, Shadrach Wamboi. I have the honor and privilege of introducing counsels for the petitioner. I appear alongside my learned senior, Mr. Dunstan Amari.
I'm present.
Mr. Samson Nyaderi, my senior.
I'm present.
My learned colleague, Mr. Nicholas Karanja.
I'm present.
And my learned colleague, Miss Melissa Omeda. We all appear for the petition applicant. Thank you.
Yes.
My Lord, in that matter, I am Shadrach Mose, the Solicitor General, appearing for the Attorney General, together with Professor Gitu Muigai, Senior Counsel, Emmanuel Peter, Deputy Chief State Counsel, Charles Mutinda, Deputy Chief State Counsel. Much obliged, my lord.
Thank you.
My lord, if may please in the matter, Milimo, my lord, I appear alongside Ole Kuyoni for the first respondent.
May it please you, my lord. For the second respondent, my name is Gumbo. I appear together with the learned senior colleague, Mr. Paul Nyamodi, and Mr. Honorable Gitonga Murugara.
May it please, my lord, my lady. That matter, my name is Edwin Kelly. My lord, I appear together with my senior Professor Ojenda, my lord, Senator Hilary Sigei, and Ms. Mercy Kanji, for the third respondent, my lord, in respect of his matter.
For the third respondent.
For the third respondent, Speaker of the Senate.
The Deputy President is the interested party, and I appear with my colleagues, Mr. Ngoya, Toma Charia, Jomo, Degwa, Kimpa, Wandati, Victor Swanya, Faith Muge, Faith Bible, and Mr. Muge.
And Mr.
Muge, for the interested part, that is the deputy.
Thank you, my lord. My lord, just to respond to the question whether this petition should be consolidated with the others, the questions that have been posed in the instant petition question the constitutionality of the impeachment process at the Senate that led to the removal by way of impeachment of the Deputy President. Secondly, my lord, it also questions the constitutionality of the appointment of Professor Kithure Kindiki as the Deputy President designate in that office. And for that reason, my lord, the view that we take with humility is that the petition is ripe for consolidation, and my lord, just for the avoidance of any doubt, and my lady, we have an application filed and dated the 18th day of October 2024 that sought an order of conservatory order to stop the implementation of the decision made by the Honorable Speaker of the Senate, Honorable Amason Kim. So, my lord, when we canvass, or we are to canvass the applications as to whether the current conservatory order should be disturbed or not, we want to actively, and we seek with humility, to participate in those proceedings. Thank you.
Is there the parties, are you opposing the possible consolidation?
Yes, my lord, we are vehemently opposed, my lord, to the joinder or intended consolidation of this petition. And my lord, so that we don't take time before you this evening, we will prefer, my lord, that this matter also takes the cue of being mentioned tomorrow with the other, my lord, where we will substantively, my lord, be presenting, my lord, before you reasons why this matter should not be consolidated with the one that is before you today. And my lord, so that we save time, I speak for all the respondents.
Mention tomorrow.
Sorry, my lord.
Mention tomorrow.
We mention tomorrow.
Yes.
My lord, if you permit me. My lord, there is a mischief that we need to cure or to safeguard ourselves against. My lord, there is an attempt to have a litigation by way of installment in this matter. So much so that, my lord, if you look or you find time to look at the petition and the application, you will see that the issues that are raised by my seniors and counsels for the petitioner are synonymous, they are the same.
So since it is not consented to, why don't we listen to it tomorrow?
Most obliged, my lord, because the question of consolidation is a question of law and it's purely on a principle question.
Yes.
And my lord, we will be ready to argue the question of consolidation as and when we are invited. Thank you.
All right.
Yes, please.
Proceed.
And my lord, my lord and my lady.
Yes.
Yes, I am guided by my senior counsel, Paul Muite. The question of consolidation is one that even the bench, as it is currently constituted, can actually look at the matters and on its own motion, suo motu, give directions or orders, whether it is deserving to be heard alongside the other matters, or we just need to take a cue behind other petitioners.
So, my lord, the court has spoken.
Let's consider that issue tomorrow.
Most obliged, thank you.
572. 522. 522. This file has a mention date for 29th of October, but because issues are arising, we wanted to mention it again today if there is any issue arising out of it.
In terms of appearances, and in order to save the court's time, the same counsel that I enumerate are appearing for the petition, the Deputy President, in this matter.
Yes.
Yes, my lord, for the respondents, the quorum is similar, my lord, so that we stay on time. My lord, we will be waiting, my lord, to present before court two options. Either, my lord, we retain the mentioned date that has been given, or, my lord, you mention the matter tomorrow, so that if there is any party who will want to address you, we'll address you tomorrow, my lord.
We don't want back tomorrow with so many matters. If there's no need, we can retain the 29th.
We can retain the 29th, my lord.
This is the lead file, isn't it? So we have to mention it because it is the lead file. You will create the first cohort.
Okay, we can mention it tomorrow. Let's mention the matter tomorrow. So we are clear with the mentions. We can go back to petition number 565.
No, you have not mentioned my matter.
Which one?
5 509. 509.
It was consolidated in 5.
Sorry, I'm sorry, I never heard you call it out. I'm sorry, Mr. Kit was keeping me busy giving me. My Lord, in that respect, we have an application. I hope it's on record. We could also mention and get directions tomorrow on my application for the recusal of the bench dated the 22nd. I would be most obliged, Lordship.
We are mentioning the matter tomorrow.
Most obliged.
So then we are back to the petition number 565.
We wish to confirm that on the part of the Attorney General of the Republic, we are ready to argue our application certified urgent by this court or by the court referring the matter to this court.
I believe this is the matter that we had earlier indicated, that after all these matters have been considered, directions have been given in this matter, specific directions need to be given for purposes of that matter. And for purposes of enabling those specific directions to be given, I want to point out 3 things. Number 1 is that we would need directions on when the first application that was to be done after the validity application is determined, when we are going to be had. That is issue number 1. Issue number 2, my Lord, that is important, is the fact that now that today the Honorable, the Chief Justice has caused all of us to come on the basis of these other matters, the point needs to be noted that for purposes of the basis for all these matters that empanelment was done, the reason was that there were applications for conservatory orders. Those applications for conservatory orders were first certified as urgent and would be the first business of this court appearing there, assuming there is no other preliminary issue like recusal or other ones. Thirdly, my Lord, is this, that for purposes of those applications where conservatory orders were made, the conservatory orders may have been made in 2 or 3 files, but they conserve the status, quo that is cross-cutting in all the petitions that are before you. Apart from the fact that in that particular petition, the one that has conservatory orders, when this court, because all those applications were done on Saturday, the parties, starting at least with those that I represent, because of the nature of the proceedings that were there yesterday, we have not completed doing the responses to the applications by the Attorney General to lift conservatory orders. We could not be able to do the authorities for reasons that were indicated. And more importantly, my learned colleague, Mrs. Kemodo, whose file has been consolidated, did indicate she has not even been served, and in that matter, she needs to respond and be heard. Therefore, my Lord, in considering this issue that is itching the group that wants lifting of the orders, I would like the court to give directions bearing in mind that the stakes of the parties, all the people who have filed petitions, is to ensure you are not faced with a fait accompli, where you are told, we have already sworn Kindiki and you can go to hell. We do not want to be faced with a fait accompli situations. My Lord, it would be absolutely important that the subject matter is preserved, if not for any other day, until all the parties are before the court. Your Lordship.
Your Lordship, there is this, you can see that we are consulting
Now we will proceed in these matters as follows. By tomorrow, we will issue comprehensive directions on various issues. But importantly, parties are already aware that there are two cohorts of matters. The first cohort involves the petitions which were filed challenging the happenings before the National Assembly. Those petitions will proceed as cohort 1. They are the subsequent petitions which were filed challenging what transpired in the Senate. That is cohort 2. By tomorrow, we will deal with the issue of consolidation. We are aware of the powers this court has on the issue of consolidation, just like how we exercised the powers yesterday. We may decide to either hear or give directions on the consolidation. However, we are in agreement that the next application in line can only be one, and it is the application for recusal of this bench. And that is the application which, after we do everything, tomorrow at 2:30 is up for hearing. If you intend to participate in that application, in the second cohort, that application is coming up for hearing tomorrow at 2:30. In the morning, we will deal with the issue of consolidation. That one we will give directions on that. So that is the way forward. Prepare to hear the application for recusal of the bench tomorrow at 2 p.m. In the morning, we will deal with the procedural issues of consolidation and any other issue which may arise in cohort 1 and cohort 2. Thank you.
And those are very clear directions about your leadership. And we entirely agree that we will assist in the orderly progression of the hearing of these matters. Thank you.
Just for the record, my lord, we assume it is all the 3 applications for recusal because
there will be no other application for recusal. We will hear what is on record, and it will be a ruling will be delivered. There will be no other application for recusal. And we think that that should come first, because if you don't want the bench, there's no reason why we should do any other thing.
My lord, I was only pointing there are 2 or 3 of them.
Yes.
And the only clarity I'm asking is whether all applications for recusal will be handled together.
Yes, together. All will be handled together.
Yes.
Your Lordship, finally, as you categorize these pleadings in cohort 1 and cohort 2, kindly allow me to remind the court that the last time we were before you on the 16th, the court gave or granted leave for parties to amend their petitions. So there could be petitions that have now crossed over to cohort 2, pursuant the amendments bring in light the transpired. Perhaps the pleadings will be as witness.
Mr. Ndegwa, those are some of the preliminary issues which we'll deal with in the morning. But principally, prepare to argue your application for recusal at 2:30.
I am ready even now.
Before we break, and with your very kind permission and indulgence, I would like to put the deponents of the affidavits that have made very, very grave allegations about judges of this court to be present tomorrow at 2:30, because we reserve the right to cross-examine those deponents and to move the court as appropriate after that.
Yes.
Well, perhaps if I may request that the court supplies us with a typed copy of the ruling that you have delivered today. We know you are working under very tight timelines, but we would very much appreciate a typed copy of the ruling that you have delivered today. We believe it may be useful in the tasks at hand tomorrow.
Finally, Your Lordship, this is the ruling that you delivered on 16th of October in the consolidated petition 522. Maybe we can get a copy of that ruling as well.
The ruling should be available. So, yes.
Finally, my judges, I think there is a law about service, that there are some parties who are present and have not been served, and we've been hearing this from the inception. I think tomorrow we settle the issue of service. We also settle the issue of filing of any affidavit or responses that ought to be done, so that after 2:30 we know how best we're going to proceed without people intervening with I have not had sufficient time to this or that.
And I think before my presiding judge addresses, I just want to remind the parties that we are using technology to move. To me, the issue of service should not be a big thing, because if you are mapped into a matter, automatically you get everything, unless you are not in the system. And if you are not in the system, get in touch with the deputy registrar. As simple as that. So that we avoid these issues of I was not served, I was served, I was not served. Let us make use of the technology at hand. Thank you.
May I suggest that, Lord, we are appearing tomorrow in the ceremonial hall at 11. I was going to plead that any other issues being raised from the bar be raised tomorrow at 11.
No.
As the chair in fact of all the people who are retiring, on this particular topic, all people
Is it 9 or 11?
Just to avoid any doubt, the application for recusal will be heard at 2:30. Whether you have responded to it or not, we will hear it. We will not allow any adjournment on it.
At what time tomorrow morning, sir? Because some of us need to get there.
Tomorrow morning at 9.
At 9, yes.
Yes.
And what you told you that? It's at 9 o'clock.
Yes.
We're most obliged with us. We can see it.
For clarification purposes, is it physical or you can do virtual both?
So I think that concludes our sitting today. That concludes our sitting today. See you tomorrow.